Hi everyone, my name's Shazia Khan and today's session is on the unit Law and Financial Crimes, and the unit learning outcome we'll be doing today is learning outcome 4, which is to understand the development of global financial crime and the international initiatives in regulating this area. So before we go on to learning outcome 4, I just want to go through what we did in the last session, which was learning outcome 3. So in the last session on learning outcome 3, we looked at understanding the regulation and commercial policy issues relating to white collar crimes. We looked at the elements of what white collar crime is and why it's so important in regards to identifying this. We also looked at a video on white collar crime. We looked at the aim of those committing white collar crime and what they are referred to as white collar criminals. We also looked at the types of white collar crimes such as fraud, embezzlement, bribery, tax evasion, money laundering, insider trading, extortion, etc. We then went on to look at 3.1, which we looked at analysing the historical development of white collar crime and the role in statutory law in dealing with this. So we referred to the traditional ideology of Sunderland and what he identified as white collar crime and what elements of white collar crime came around in the 1930s. We then went on to look at the elements of the role in statutory law in dealing with white collar crime and what white collar crime is meant in the UK, but also looked at laws in the UK that dealt with white collar crime, things like Fraud Act 2006 and the Bribery Act 2010. We looked at 3.2 and we looked at evaluating the role of criminal law in supporting prosecution of white collar crime. And we looked at the element of the serious fraud organisation in regards to that, different organisations that dealt with that. And we also looked at the Bribery Act and the actual Fraud Act in relation to the criminal offences. We looked at 3.3, critically analysed civil remedies in the context of white collar crime. We looked at the FSA in regards to white collar crime and how that has an impact on the proceeds in regard to white collar crime. We also went on to look at civil remedies that are available for white collar crime in recovering any sort of damages of fraud or embezzlement. We looked at 3.4, which was to analyse defences and what extent these need to be developed in regards to white collar crime, and demonstrated things of deceptive nature and the grounds. We also looked at common defences for white collar crime, and some penalties include things like victim restitution, steep fines, prison time, property forfeiture, probation or community service. We also looked at some common defence tactics used against white collar crime charges, such as entrapment, lack of intent, illegal seizure or search, statute of limitations, intoxication, coercion or duress, and insanity. We then went on to look at whistleblowers in preventing white collar crime, so how they play a role in the preventative method of white collar crime. We looked at real world examples of white collar crime, things like Enron Corporation, WorldCom, Bernie Madoff, Instock, Adelphia Theatre, Tyco, HealthSouth, Jack Abramoff. We then went on to look at elements of white collar crime is so important in regards to society and why financial crimes need to be dealt with. So that's just a quick overview and a summary of learning outcome 3 in regards to dealing with white collar crime and looking at the elements of white collar crime. Now we're going to go on to learning outcome 4, which the slides are up for you there, and it is to understand the development of global financial crime and international initiatives in regulating this area. So keywords here: money laundering, which is the concealing of, disguising the origins of illegally obtained proceeds so that they appear to have originated from legitimate sources. It's frequently a component of other serious crimes such as things like drug trafficking, robbery, or extortion. So this happens not just in the smaller scale, but also in the large scale, where the large organizations will launder money to hide any sort of illegitimate sources. Corruption, which is a dishonest behaviour by those in position of power. Those who abuse the power may be individuals of organisations, large organisations, such as business or the government. And then we've got cybercrime, which is a criminal activity that involves a computer, network, or network device. While most cybercriminals use cybercrime to generate a profit, some cybercriminals are carried out against computers or devices to directly damage or disable them. So these are some of the key indicative content to be looking at, understanding the responsibility placed on an organisation to identify interactions, money laundering, why it's so important, terrorist finance, and that's a big thing as well, where people actually finance things through terrorist means of weapons and things. Corruption, the EC Market Abuse Directive, we'll be looking at criminal law, civil recovery, reporting mechanisms, Financial Action Task Force, cybercrime and recent developments, foreign exchange, international conventions, reporting mechanism analysis, and international initiatives. So there's a growing consensus of global financial crime within the institution. So financial crime is both a contributor to societal ill and a threat to financial stability and financial inclusion, and its mitigation and prevention must be prioritised. While billions have been invested to tackle this type of criminality, greater emphasis needs to be placed on bolstering the efforts of law enforcement within the help of private sector and ensuring the legal and regulatory framework and financial crime risk management toolkit are enhanced to enable stakeholders to achieve more effective outcomes. This is not to say that progress has not been made in this area, because it's a huge area that's been dealt with for a long, long time. And the main element of it is the Financial Action Task Force, FATF. It's in its 13th year, has led the way in internationally coordinated action to reduce any sort of cross-border financial criminality, and continues to do so in identifying any sort of new dynamic areas and any sort of reforms that need to be made to introduce new ways of working, and the deployment of new technology. AI is coming, other technologies are coming to try and prevent any sort of financial crimes within the financial industry, and within a global basis as well, because this appears to be happening not just nationally but globally. There's so much issues of financial crime occurring globally, and the FATA have to deal with this and adapt to new changes as well, because it's there to try to combat any sort of new forward thinking, and trying to identify any sort of comeback for trying to prevent any sort of financial crime occurring. So 4.1, compare and contrast historical and economic general provisions of law on money laundering, terrorist financing and contribution. So anti-money laundering and combating finance of terrorism. So over the past 20 years, the fund has helped shape the anti-money laundering policies globally within its members' national frameworks. Financial integrity issues are covered in all functions: surveillance, lending, capacity development. The financial sector assessment programs, FSAPs, are working with the anti-money laundering institutions and funds to try to design and implement any sort of integrity measures into fund programs. And the whole point of these fund programs is, through participation and assessment, try to coordinate any sort of financial any sort of financial crimes that are occurring, because it's a big concern within that. In regards to terrorist financing, sorry about that. Anti-money laundering and countering the financing of terrorism. So terrorist financing refers to the act of providing financial support to terrorist activities, whether through funds, assets, or other sources. While it shares similarities with money laundering, in both involve concealing the origin of destination of money. Terrorist finances is unique in its purpose and implications, unlike money laundering, which aims to legitimize ill-gotten gains. Terrorist financing sole purpose is to fund activities that promote terror and violence. So it's quite important in regards to terrorism to identify these elements. So terrorist financing in the UK can come from various sources and be funneled through different channels, and it could be things like legal sources. So sometimes funds generated to legitimate means, such as businesses or donations, are diverted to support terrorist activities. Another channel could be criminal activities. So activities like drug trafficking or robbery can generate funds for terrorists. Another channel is overseas funding. So money can be sent from abroad, either from state sponsors, sympathetic individuals, or other terrorist organizations. Another channel can be online crowdfunding and cryptocurrencies. Increasingly, online platforms and digital currencies are being used to raise and transfer funds anonymously. The financing of terrorism poses serious threats to the UK's national security, by enabling terrorist operations. So funding provides the means for terrorists to plan and execute attacks, purchase weapons, and recruit members. It undermines social cohesion. So the fear and mistrust that terrorism fosters can fracture communities and erode social bonds. It affects international relations. So the UK's ability or perceived ability to control terrorist finance within its borders can impact its standing and relationships with other nations. So recognising the gravity of this issue, the UK has taken vigorous steps to combat terrorist finances. So they have regulatory measures in place, such as laws as Terrorist Act 2000 and the Proceeds of Crime Act 2002, which lay out legal framework for prosecuting those involved in terrorist financing. They also monitor and intelligence agencies like MI5 and the Joint Terrorism Analysis, GTAC, work direct and detect, disrupt any sort of terrorist financing networks. They have international collaboration, as the UK collaborates with international bodies such as Financial Action Task Force, which we mentioned earlier, FATF, to develop and enforce any sort of global standards, and also educating financial institutions, so providing training guidance to banks and other financial entities to recognise and report suspicious activities related to terrorist financing. Terrorist financing in the UK is a complex and urgent issue that requires multifaceted solutions. So it's quite a huge part of the UK's economy, and it is happening quite a lot more now globally. It's entwining with legitimate financial system, the varied sources of funding, and the profound impact on national security make it a priority for law enforcement, regulators, and the financial sector. So it's really, really a huge part of the country, and it needs, there are national security elements there, and, law enforcement needs to come into place quite quickly and quite rigorously if the changes to law need to be made. The UK's comprehensive approach accompanies legal, intelligence, educational, and international strategies, illustrates a resolute commitment to addressing this threat. Continued vigilance, innovation, and international cooperation are essential to terrorist financing and ensuring that the safety and stability of both the UK and the broader global community, so that, elements are protected, people are protected, national security elements. So let's go. So in regards to the EU level, it is essential that gatekeepers, banks and other obligated entities apply measures to prevent money laundering and terrorist financing. Traceability of financial information has an important deterrent effect. So the European Commission carries out risk assessments in order to identify and respond to risks affecting the EU internal market. The European Union adopted robust legislation to fight against money laundering and terrorist finances, which is the anti-money laundering regulations. The first anti-money laundering directive was adopted in 1990 in order to prevent the misuse of financial system for the purpose of money laundering. It provides that obliged entities shall apply customer due diligence requirements when entering into business relationships, so to identify and to verify the identity of clients, monitor transactions and report suspicious transactions. The EU laws have been constantly revised in order to mitigate new risks relating to money laundering and terrorist financing. The legislative framework not only covers a range of areas posing such risks, including virtual assets and crowdfunding, but also complements other risks such as markets in crypto assets regulation, MICA. The new regulation on the traceability of transfers of funds, TFR, ensures the traceability of crypto assets transfers and the authentication of the users, aligning with the FATF standards. The Commission ensures effective application of this legislation by reviewing transposition of EU law and cooperating with competent authorities. So corruption. Corruption is a complex phenomenon and can occur on different scales. Corruption ranges from small favours between a small number of people. So that's things like petty corruption, and to corruption that affects people on a large scale. So, you know, it could be a huge amount of corruption there. And corruption that is prevalent, that is part of everyday structure of society, including corruption as one of the symptoms, organised crime. Corruption is corruption of the rich is particularly hard to measure and largely excluded from conventional metrics like CPI. Analyze 4.2, analyze the EC Market Abuse Directive to control market manipulation. So the Council Directive 2003/6/EC on the insider dealing with market manipulation, which was aimed at reducing market abuse and which aimed applied to any financial instrument admitted to trading on a regulated market or in respect of which request a request for admission to trading had been made. The Market Abuse Directive and its implementing legislation were repealed and replaced by the EU Market Abuse Regulation, EU MAR, with effect from 3rd of July 2006. So the EU Market Abuse Regulation, it came into force in 3rd of July 2006, and this rescinds the previous Market Abuse Directive 2003/6 EC MAD, replacing it with an extended scope. The original concept behind MAD was to create a unified framework for EU-wide market abuse regulations to ensure an effective and coherent informational workflow across the member states. In doing, the legislators hope to demonstrate the robustness for outside investors and better cross-border cooperation. The idea of this new, stricter form of market abuse legislation is to strengthen market integrity and investor protection and to guarantee a universal playbook across all of EU member states. MAR not only fortifies previous legislation, but also enhances it by extending its scope to introduce new offences. By doing this, the regulation hopes to increase activity in the securities markets. According to the Financial Conduct Authority in the UK, MAR aims to increase market integrity and investor protection, enhancing the attractiveness of securities markets for capital raising. The term penalises insider trading, market manipulation, and unlawful disclosure of information. It gives national regulatory authorities the responsibility to detect and protect against market abuse, while instilling these bodies with the power to enforce sanctions against non-compliant parties. MA also outlines provisions for detection and compliance. What is market abuse? So market abuse refers to the practices of misusing information in order to disadvantage financial market investors or to gain unfair advantage as an investor. This is usually done in three ways: using advantageous information and that the public do not have, distributing incorrect information, or skewing price setting mechanism of financial instruments. So the first one on here is the insider dealing. So there are three categories of market abuse in regards to it: insider dealing, unlawful disclosure of information, and market manipulation. So the first one, insider dealing, dealing refers to the use of inside information to execute deals to one's advantage. This includes the execution of orders based on inside information, as well as cancellation and amendment of orders based on inside information. For example, a company executive knows the company is about to receive a large funding deal. This company executive would execute a trade knowing that the company's share prices will go up. This would be considered insider dealing because inside information is being used as an unfair advantage. Importantly, MA specifies that insider dealing is not only covers the execution of trades, but also amendment and cancellation of orders based on inside information. For example, imagine a company executive places a large order but finds out that the CEO is stepping down within the next month. Cancelling or amending this order based on this inside information before the information is made public would be classified as insider trading. Equally, the market abuse regulation puts measures in place to prevent collusion between third parties. The regulation also prevents persons with access to inside information from leveraging that information to encourage a third party to place, amend, or cancel advantageous deals. This includes offering up tips and recommendations to another person to place transactions based on inside information. Unlawful disclosure of inside information. So unlawfully disclosing inside information occurs when a person with access to inside information passes that knowledge along to another person. The only exceptions is that if the disclosure is regular, face it, of the person's employment or professional duties. Market manipulation. So the definitions for market manipulation are laid down in Article 12 of MA. It refers to the act of misleading the market through certain activity or to activities that manipulate the price. In line with this, the market abuse regulation prohibits persons to place orders or behave in any way that offers purposely misleading signals regarding the supply and demand or a financial instrument or its potential price. To support this, it's also forbidden to produce and distribute information that purposely misleads the market on supply and demand or that indicates a false price. Extending the scope from the previous legislation, the market abuse regulation explicitly outlaws the manipulation of benchmarks. Article 12 specifies that market manipulation can include the collusion to secure a dominant position over the supply or demand of financial instruments, auction products, or spot trading commodities with the view of creating unfair trading conditions. The act of distributing or delaying trade systems is also considered to be market manipulation, as well as overloading or destabilization of orders books. Market manipulation regulations relate to financial instruments traded on regulated markets. This includes securities, but also extends to derivative transactions, spot commodity contracts, and market instruments if affected by price value of the market instrument. So the main laws related to market abuse. In the UK, there are criminal and civil laws prohibiting market abuse. So we have in the UK, insider dealing is not a civil offence under the UK market abuse regulation. It's also a criminal offence under Part 5 of the Criminal Justice Act 1993. To prove a criminal offence, you need to provide evidence of intentional use of inside information, which is information that's not known to the public, to deal with in publicly available price-sensitive securities. The offence can only be levelled against someone, so that can be an insider who had and knew they had inside information. Also, the insider must have knowingly received the information directly or indirectly from an inside source or procured it from the particular role. The inside information must have been specifically related to particular securities or issuers. Also, it would only be insider information if it would have been likely to have had a significant effect on the price of securities if it were made public. Civil offences, so the EU MAR came into force in July 2016, as we mentioned earlier. A decision taken to onshore the MAR in the UK law on 31st of December 2020 by the European Union Withdrawal Act. After authorities made minor changes to the market abuse exit regulations, the UK MAR was born. The main difference between the UK MAR and the EU MAR are the notification requirements for delaying the disclosure of inside information, or notification requirements for transactions of persons discharging managerial responsibilities, which is PDMRs, and the reporting of suspicious transactions and order reports. Furthermore, the relevant European Securities and Markets Authorities guidelines and recommendations are not incorporated into UK law. However, the FCA has made it clear that they expect all market participants to continue applying the ESMA guidelines before the end of the transition period where relevant. The UK legislation covers dealings that affect qualifying markets. These are a UK or EU-related market, a multilateral trading facility, MTF, an organised trading facility, OTF, and any other financial instrument of value. Therefore, dealings in private companies and commercial properties are not subject to the legislation unless the dealings affect a qualifying market. 4.3, evaluate the reporting requirements and impact this has on global financial market. The financial crime presents significant challenges for organizations globally, with repercussions ranging from financial loss to reputational damage and legal consequences. You know, there's issues around financial loss which impact it quite a lot. You know, you could have things like, you know, it would have, you know, a risk on the globe, so developing a global compliance framework. You know, things like implementing cross-border due diligence using the KYC processes, you know, they're really important in regards to due diligence. Also, things like, you know, it could be things like, you know, technology for global monitoring. So technology is changing, it's transforming the way we manage any sort of financial crime, and companies that do not embrace these advancements are risk behind. So the KYC automation will improve that. Also, things like facilitating cross-border collaboration, you know, is a key for seamless operations in global company. The aim is to participate into sharing initiatives, improving data quality and its use, maintaining a unified risk management approach, things like, you know, financial crime management, maintaining a risk management approach for global organizations as well as national ones. So the financial crime encompasses a broad range of illicit activities that undermine the integrity of financial systems and institutions. It involves illegal, unethical actions aimed at defrauding or manipulating financial processes for their gain. Some of the most common ones which look at fraud, bribery, money laundering, and it goes further on in regards to that. Key international AML regulatory bodies, so A variety of regulatory bodies exert to protect everything, and regulations are put in place. These regulatory bodies include the Financial Action Task, the European Union, and the United Nations. So the Financial Action Task Force is an intergovernmental body established in 1989 to combat money laundering, and has since expanded its mandate to include counter-terrorist financing. It sets out standards for anti-money laundering measures known as the FATF recommendations, which countries are encouraged to implement into their national legislation. These guidelines impact global anti-money laundering regulations, significantly shaping national policies to ensure effective prevention and detection of illicit financial activities. The Financial Action Task Force also monitors the progress of its members and implementing these recommendations, providing an essential level of oversight and encouraging international cooperation in the fight against money laundering and terrorist financing. For the EU, the European Union has implemented a series of directives to combat money laundering, and the element of that comes including things like effective KYC, which is, know your customer fundamental components that have been implemented. The directive are continuously revised and updated to address new threats, vulnerabilities, making the EU's anti-money laundering framework one of the most robust and dynamic in the world. The EU's anti-money laundering laws and CTF significantly shaped the regulatory landscape within its member states and often influences AML. In regards to the United Nations plays a crucial role in global anti-money laundering framework through its various resolutions and conventions. The UN Convention Against Illicit Traffic in Narcotic Drugs and Psychotic Substances, the UN Against Transnational Organized Crime, and the UN Convention Against Corruption of all include provisions to combat any sort of money laundering. These conventions mandate member states to implement laws against money laundering and promote international cooperation in investigating and prosecuting such crimes. Customer diligence, which we looked at, CDD and KYS, are fundamental components of anti-money laundering. The legal basis for CDD and KYS are that the legal foundation is that in the UK it stems from the Money Laundering, Terrorist Financing and Transfer of Funds Information on the Payer Regulations 2017, and these regulations specifically outline the CDD and the KYC requirements for financial institutions, and the Financial Conduct Authority FCA guidelines, where the FCA provides detailed guidelines on how financial institutions should implement the customer due diligence and the know your customer elements in regards to their procedures being implemented. The key components of the CDD and KYS is that financial institutions must verify the identity of customers using reliable independent source documents or data. Identifying the ultimate beneficial owners of legal entities is a crucial part of the customer due diligence. Firms must understand the purpose and intended nature of the business relationship, and continuous scrutiny of the business relationship and transactions is necessary to ensure customers have consistency. And assessing the risk related to money laundering and terrorist finance is vital, and procedures must be adjusted accordingly. So they are, if you failure to comply with any CDD and KYC regulations may lead to significant penalties, including fines and regulatory actions by bodies like the FCA. So, they are central to the UK's approach to combating financial crimes like money laundering and, terrorist financing. And financial institutions must navigate these complexities to ensure that they're adhering to the legal requirements. So number 4.4, evaluate the role of criminal law in supporting financial regulations in the UK. The United Kingdom's commitment to anti-money laundering, laundering and counter-terrorism (CTF) is more than a legal obligation. It's a crucial part of ensuring financial stability and protecting national security. Money laundering disguises the origins, as we mentioned earlier, of ill-gotten gains, often fueling further criminal endeavours, whilst terrorist financing supports activities that threatens lives and undermines democracy. These both intertwined issues have a global reach, but their impact is clearly felt within the UK, affecting everything from individual financial institutions to the nation's standing on the world. The UK has implemented, as we mentioned, going through these slides, a series of laws and regulations, including money laundering, terrorist financing and transfer of funds regulations, 2017. And this framework aligns with international standards enforced by various regulatory bodies, including the FCA, which is the Financial Conduct Authority, and the regulations impose strategic requirements on financial institutions to monitor any sort of transactions. Sanctions and watch lists in the UK. The legal basis for imposing sanctions and maintaining watch lists in the UK include the Sanctions and Money Laundering Act 2019, which is called SAMLA. This act enables the UK to implement its sanctions regime independent of European Union following Brexit. The next one is the legal framework is the Terrorism Anti-Asset Freezing Act 2010, which provides for freezing of assets of suspected terrorists. Various nations, United Nations and international agreements, the UK abides by global sanctions imposed by the UN and other sanctions. The UK imposes several types of sanctions depending on the objectives, things like financial sanctions, and these include asset freezes, restricting access to financial markets, and limitations on financial services. You have trade sanctions, and these involve restrictions on the export or import of goods and technology. And then you have travel sanctions, and these can include visa or travel restrictions on specific individuals. The Office of Financial Sanctions Implementation, OFSI, part of HM Treasury, is responsible for implementing and enforcing financial sanctions in the UK. They look at sanction lists, which OFIC maintains lists of individuals and entities that are subject to sanctions. Guidance and compliance, so the OFSI provides guidance to businesses and monitors compliance with the sanctions. The OFSI can impose penalties for breaches and sanctions, including fine and criminal prosecution. Watch lists in the UK serve to flag individuals or entities that may be involved in suspicious activities. This contains information. Terrorist watch list. This contains information about individuals suspected of being involved in terrorism. Proliferation watch list. This includes entities involved in proliferation of weapons or mass destruction or other thematic watch lists. This may cover areas such as human rights violation or corruptions. 4.5, critically analyze the international role in developing mechanism to regulate financial crime. So cross-border financial crimes represent a significant challenge for the global sector, such as criminal activities transcend national borders, from money laundering and terrorists to cyber fraud and corruption. And these illicit activities pose a threat to the financial institutions worldwide. The Global Financial Compliance Crimes Compliance CFC and Money Laundering Investigation Team is responsible for identification and reporting of suspicious crimes, international collaboration in anti-money laundering and terrorism efforts is crucial due to the nature of money laundering and terrorism and financing terrorism, which transcend national borders. By establishing solid channels for information sharing, intelligence across countries can be valuable assets. So, countries need to look at each other's jurisdiction and collaborate with each other so that they're able to establish any sort of information in regards to any sort of issues around money laundering or terrorism. Technology and the future in the UK. As regulatory requirements become more complex, the financial landscape more interconnected, technology has emerged as a central tool for compliance management in the UK. There are several advancements are driving changes in compliance, things like regulatory requirements, and this includes specialized software designed to help financial institutions comply with regulations and improve any sort of efficiency and manage risk. AI, another one, AI and machine learning. These technologies allow for predictive modeling and real-time analysis, providing insights into compliance risks. Blockchain is another one. Blockchain's transparent, immutable nature can be harnessed for secure record keeping and verifying transactions. Big data analytics, using vast amounts of data to detect patterns, trends, and anomalies, aids in risk assessment and fraud detection. Cloud computing, so enables more flexible and scalable solutions, allowing financial institutions to adapt to evolving regulatory landscapes. Technology will continue to evolve, okay, and with it, the ways in which compliance is managed. New technologies like quantum computing may eventually find applications in compliance, and in regards to globalized standardization, technology may lead to more harmonized compliance across all jurisdictions. And technology enables better collaboration and enhanced collaboration between regulators, financial institutions, and other stakeholders. One of the so anti-money laundering, counter investment, we looked at this in regards to one of the activities to prevent that would be in large investments. In last year's is AML, after a series of very notorious cases affecting large global systematic important banks and the corresponding stronger regulatory scrutiny. The year ahead, the Financial Conduct Authority ambitious enforcement plans. So in 2022, for the first time, the Financial Conduct Authority published a 3-year strategy setting out 3 themes for promoting positive change, namely, number 1, reducing and preventing serious financial harm and crime, number 2, setting and testing higher standards, number 3, promoting competition and positive change with greater regulatory openness, and the FSA pledged to fulfill 13 public commitments centered around its key issues. The strategy is now in its final year, and the FCA is focused on completing a strong stretch. The regulator recently published its business plan for 2024 and 25, which sets out challenges, areas of focus, and plans for delivering on its commitment over the next 12 months. Firstly, the focus was, as we mentioned, reducing and preventing serious financial crime. Focus 1 of the FSA's 3-year strategy is the reduction and prevention of serious financial crime, which the FSA recognised whilst on a small proportion of authorised firms cause life-changing harm, it can and does happen very quickly. And the FSA has pledged to deliver on which focus on protecting consumers by mitigating and, where possible, preventing harm can occur. The tackling of the financial harm in 2024. The FSA business plan has made it clear that the key priority for enforcement perspective is aforementioned a commitment to reduce and prevent financial crime. The FSA's business plan with its associated goals demonstrates the regulator's determination to deliver on its overall 3-year strategy. Looking critically at the substance of the business plan and the work streams identified, I will be putting the business plan on Moodle for you to have a look at, so you could have a better idea. I think it's at the link as well at the bottom in the references. The FSA fostered the reduction and prevention of financial harm, and they envisage to make ripe changes in the enforcement sphere. With regards to more in the plan, they are more likely to begin with. Firms are likely to experience more assertive supervision in enforcement to the FCA's stated focus, particularly money laundering and fraud. It's no surprise that these financial crimes have been received granular attention, particularly fraud, given the corporate criminal liability for failing to prevent fraud was introduced in October 2023 under the Economic Crime and Corporate Transparency Act. Accordingly, firms would be well advised to ensure their systems and controls are enhanced in these fields well in advance of potential regulatory scrutiny. With regards to money laundering in particular, in the plan, firms should prepare for proactive assessments of their money laundering systems and controls, especially those operating in higher risk markets. Firms must ensure that financial crime controls keep pace with business growth and must risk assess their own and their clients' activities properly. So, you know, they are going to push down on firms to do everything properly. Inadequate resourcing and assessment in this regard could lead to an increase in regulatory enforcement action, as the FSA warned in its recent market update. Moreover, the business plan notable focus on anti-money laundering related risks potentially foreshadows upcoming reforms of the UK's anti-money laundering framework. So, you know, they want to make sure that firms are following the laws and regulations that are put in place, and that firms should ensure that they're able to evidence how they can remain resilient in the face of challenges and ensure they have a robust wind down plans in place. So they are putting a stance in and becoming more stringent. They must be better demonstrate how they can protect consumers' assets in the event of disruption, particularly disruption stemming from criminal activities, and swiftly recover from any disruption. So they are making it very stringent. So hopefully this business plan will enable, you know, the changes to come into place, and, you know, the challenges that will be put into place, you know, how they can be overcome, you know, and how they will make all these changes in regard to that. So shaping the future of money laundering. So, you know, things like reducing system dependencies, using data in new ways, automated AML processes, adoption of artificial intelligence and managing learning. So to identify the shaping of anti-money laundering, the fight against, as we mentioned, the money laundering has been a global issue for decades, and the fight against it continues. And this plan that the FSA has put together may have an impact on some changes that they've done in regards to money laundering efforts through the year. You know, the fight against financial crime continues to pose major challenges to regulators and organizations worldwide. Money laundering is estimated to be 2.5% of global GDP, which I mentioned in the last learning outcome as well, and 1.87 trillion each year. About 15 years ago, the third EU anti-money laundering directive was introduced, significantly expanding the scope and requirement for the money laundering regulations. Hopefully, these new changes that will come into place will reduce systems dependencies, will seek to reduce internal, external parties, and make sure that firms are using the know to your customer solution and requiring flexibility. They'll be using data in different ways, so companies must be leverage more data sources, both from own customers and external providers, to enhance anti-money laundering capabilities and accuracies. And proactively using data in their transaction and making sure they're monitoring any sort of risk assessment as they're going ahead, any sort of cruciality around that. Automating AML processes. So companies must pursue, explore, and implement more automation in their anti-money laundering operations, such as customer due diligence, CDD and KDC, which we looked at, know your customer, KYC, and alert investigation and reporting functions. So make sure you report people. Reducing times, resources and money will be necessary to improve compliance, performance and quality to operate more efficiently. So they need to make sure they are dealing with complying with the laws, making sure they are risk assessing everything, because that's so important. Adoption of artificial intelligence and machine learning. Companies must continue experimenting with and adopting artificial intelligence and machine learning techniques in their anti-money laundering solutions, especially for pattern recognition and anomaly detection. With these technologies, it offers great opportunities. Companies must ensure that these technologies live up to transparency, explainability, and accountability to regulators and themselves. So in conclusion to learning outcome 4, the UK's legal and technological landscape in managing money laundering, terrorist financing compliance is a complex, evolving field. As we have explained in this slides, measures such as customer due diligence, know your customer protocols, sanctions, incorporation of cutting-edge technology are integral to the framework. While significant progress has been made against financial crime in the past few years, much work remains to be done. Companies must continue to innovate and adapt their anti-money laundering solutions. There's, embracing these new technologies and using data in new ways, companies can reduce burden of compliance and enhance their ability to prevent and detect financial crime. Ultimately, the success of anti-money laundering field will depend on the collaboration and cooperation between stakeholders, regulators and law enforcement, to businesses and technologies. Financial crime cases in the UK. So I wanted to give you an example of some of the cases in the UK. So we've got the banking fraudster sentenced in May 2024. A banking frauder has been sentenced for making fake applications to banks and a pension company to obtain loans, banking and pension facilities totaling around 178,000 in potential loss. Tamworth woman jailed after defrauding 634,000 from beneficiaries of wills. So 2 women from Tamworth have today been jailed for defrauding and laundering more than 634,000 from estates of the deceased, including money intended for life-saving charities such as cancer research and Great Ormond Street. So you can see that these financial crimes that are happening in the UK, it's not just in the UK. These examples are in the UK, but we've got some globally as well, financial cases globally. And an example here is the USD 300 million seized and 3,500 suspects arrested in international financial crime operation, a big crime operation in Lyon in France. A transcontinental police operation against online financial crime has concluded with almost 3,500 arrests, which is a huge amount, and seizures of $3,000 million worth of assets across 34 countries. The 6-month operation HAEGCHHE5 December from July to December 2023 targeted 7 types of cyber-enabled scams: voice phishing, romance scams, online sextortion, investment fraud, money laundering associated with illegal online gambling, business email, compromise fraud, and e-commerce fraud. Investigators worked very hard in this to detect any sort of work together with detecting online fraud and freezing associated banks and virtual assets. So, there was a lot of work gone into this to try to find out and detect all these elements of fraud. Cooperation between Filipino and Korean authorities led to the arrest in Manila of a high-profile online gambling criminal after a 2-year manhunt by Korea's National Police Agency. Authorities blocked 82,112 suspicious bank accounts, a huge amount, seizing a combined, this was a huge case, 199 million in hard currency and 101 million in virtual assets. Another really important case you can look at in your own time as well, it's the case of Nauru. Have a look. This is just a brief outline of it, but have a look in your own time in regards to this. Nauru is located in Australia and is known as the smallest island country in the world. Nauru is famous for mining and has been received a large payment from Australia for its mining profits, making it one of the richest nations in the world. In 1990s, due to corrupt government, Nauru transformed itself into a tax haven. Russian criminals took advantage of this situation and started laundering money through shell banks. So this is a huge thing. As it was a small island, it was easy. People thought, the Russians thought it was easy to kind of money launder, and through it was quite an easy thing to do. Nauru did not authenticate banking customers and did not pursue the necessary questions. As a result, Nauru helped Russian criminals launder an estimated of 70 billion in 1998. In 2002, the US Treasury designated Nauru as a money laundering state and imposed harsh sanctions, to rival those settled in Iraq. Until 2005, Nehru passed anti-money laundering and tax haven laws with the help of Financial Action Task Force, FATF. So we've now finished learning outcome 4, and the next session we've got is on the assignment discussion. These are some of the references we've used for today's session, which will help you in support in doing the assignment, but also some additional reading for you. Refer again to ebooks and any additional reading on Moodle for this module. Any questions or queries, please email learnerwork@ukvarsity.co.uk. Submission of the assignment to be done on learnerwork@ukvarsity.co.uk. These are some links to some articles you can read in your own time. Article on global financial crime and financial and compliance report, which I mentioned earlier, that you could go on and have a look at the different elements of that. So these reports are available on Moodle for you as well. Please refer to Moodle for additional reading and any sort of resources. Thank you for attending today's session, which is Learning Outcome 4. The next session we'll be doing is assignment discussion. Thank you.